Okay, so good afternoon and welcome to part 2 of our trust topic. This is the second to last topic that we'll be covering, so I'm just currently finalising the update of the notes for relationship property, and hopefully those will go up on stream in the next day or so. So yeah, just get in contact if you have any questions. Of course, as we shall see, the trusts topic and relationship property do overlap. We'll be mainly looking, and it will be quite briefly, at how the relationship property legislation in particular does give, trust busting powers to the courts in that topic rather than this topic. And then even in a limited way, because even experts in relationship property are still to some extent, taking it case by case in terms of how those relevant provisions can apply to trusts. And the law is constantly in flux and being argued about all the time among academics and the courts and lawyers, etc. So, getting on to the second part of the trusts. So last week, and we'll do a quick revision, we just had a quick look at what a trust is and the key people in a trust, etc. Today, we're going to be continuing to focus on express trusts. Those are trusts either created by way of a trust deed, or often referred to as inter vivos trusts, or testamentary and will trusts. So these are trusts that are put in writing and are very clear as to the intention of the parties, the nature of the beneficiaries, of the purpose for which it is set up, and the property that is covered. But as you will recall, there are other kinds of trusts, including resulting trusts and constructed trusts. So we'll be looking just at things relating to the administration and management of trusts, and we're going to be focusing on the Trusts Act. So as I said last week, we're taking a future focused approach here, not talking a lot about how things used to be. And we're going to look at obligations of record keeping, appointment and removal of trustees, and exemption and indemnity clauses. Then we're going to look at the duties of trustees and the rights of beneficiaries. The rights of beneficiaries in particular is a developing area, particularly with this new trusts law. And it's one of the things that did prompt a lot of review of trust deeds and anxiety among some sort of set laws regarding the trusts, particularly in family trusts. And then very briefly, just touching on the powers of the court when something goes wrong, or there are just questions relating to the administration of a trust. Note just for your record. Okay, so just as a quick revision, just so it's on the top of your mind while we're talking about these things, in the last topic, we looked at a definition of a trust, and particularly the fact that a trust is a legal concept, not a legal entity. And that can be a bit hard to get your head around, but effectively a legal entity is something like a company, an incorporated society. It has its own legal form versus a trust, where it is the trustees who hold the legal ownership of something and the beneficiaries have that equitable interest in the property. We had a look at why you might use a trust and trusts and estate planning. We looked at the types of trusts. We compared trust to other relationships, including agency and contract, etc. And we had a look at how the Trust Act applied, the core people, issues relating to transferring of assets to a trust, and distributions. Does anyone have any questions about what we covered in the first session that have occurred to them after that? No, if you do, if any questions do occur to you, then put them in the chat, and I'll try to either respond directly or even in a forum message. Okay. So the basics are that to be effective as an estate planning entity, a trust requires, you've got to first have the well-drafted trust deed, and it's got to be fit for purpose. So what that means is you can have a really fancy trust deed, but if it isn't tailored to current circumstances and to the needs of the parties and what the settler wants, how the trustees will have to operate, etc., then you could be left with a pretty piece of paper that isn't actually that helpful. Then you also need the right trustees, and those trustees are people who understand their duties and are able to comply with them. And that can be an interesting issue for particularly family trusts. Often the trustees may be family members or even the settlers themselves. And particularly as trust management and administration becomes more complicated, that can mean that even well-intentioned decisions can be wrong. But those parties may not, for understandable reasons, want to pay for an independent trustee, and you might not want to get a family friend, etc., to be a trustee, and that family friend might not want to have those duties and obligations, particularly since they would be doing that for free, usually. And you need good administration and management. And there are whole books on this. There are businesses who will set themselves up for assisting you with trust management. There's software, I believe CCH, who have the IntelliConnect, the sort of Wolters Kluwer information. They were also spruiking to our law firm when I was leaving their trust management database, which will keep together all the information that you need to know about who the beneficiaries are, purposes of the trust, etc. You need sound decision making with that reference to specialist advice is appropriate. And that's where you will see those provisions within the Trusts Act now of both paid advisors with reference to drafting the trust deed, but also special advisors that are not trustees but can be brought in to assist with trustee decisions for whatever reasons. Often, for example, things like investment decisions would be something that you would be pulling specialist advice in, but also the complexities, as we'll see. For example, if you've got an issue with a beneficiary, you may get some specialist advice on that. And you need to be keeping good records of what you do and why you do it. But even the best run trust, you'll have some things that are outside the control of both the trustees and their advisors, and that includes the behaviours and expectations of the settler. So the settler may set up a trust not completely understanding, one, that it is separate from them, that they do give up essential legal control of those assets to the trustees. And so they may wish to have a degree of intervention that isn't appropriate. And also the beneficiaries. So some beneficiaries could just be more difficult than others. They could have expectations of the trust which may or may not be reasonable, and they could be litigious. So they could wish to take the trustees and the trust to court to challenge decisions. The circumstances of the trustees could change. And a simple example of this is you get, you're a trustee of a trust for your friend, but you get offered a job in Australia. You could, still continue to be a trustee from Australia, but that distance could be, make it more difficult. And so you might need to leave. And also those concerns relating, for example, to the capacity of trustees. And that is their ability to make decisions. And that's coming to be an issue, particularly now, because many of the existing trusts were set up at a time where the current trustees, when they're the husband and wife who settled the trust, for example, they're getting old. And so it's becoming increasingly common for trustees to lose capacity. And then you have to deal with all of those issues, or the trustees just die. And then we've got, for example, just the general developments in the law and tax policy, etc. So You may have seen, I believe that it will be covered in part 2 of the course, but the IRD is rolling out new disclosure requirements for trusts, and that includes financial reporting. And that's from 1st of April. And so, for example, even the best planned trust, you could possibly see that, you know, this coming on the horizon, but it's not within the control of trustees. And also this constantly developing law, particularly in the area of relationship property, which can't always be planned for. Any questions, comments so far? Okay, so you've got some core documents. And the core document, of course, is going to be the trust deed. By deed, we mean a particular kind of document that is signed and witnessed in a way that isn't in a contract. If you recall contract law, if you've done it, a deed can be signed where there is no consideration between the parties, and all sort of transactions relating to interest in property must be recorded in writing, which in accordance with the Property Law Act, which is why it's in writing. And also any variations made to the trust deed or the trust. And so all trustees need to have a copy of that. But there's a number of other trust documents that must be held by at least one trustee. And that's, you can see all that, it's just like records of the property, records of the decisions, contracts, accounting records, the documents for the appointment, removal and discharge of trustees. They can get really interesting when you've got a trust that might have been operating for 30 years. You'll have changes of trustees, which are regularly documented. Then you go, for example, to the bank for a mortgage, and you will need to dig out every document showing that chain of appointments and removal and discharge of trustees, because the bank will require that for their due diligence. So can be quite complicated just to follow the trail of who is or is not a trustee at a particular time, because also that's relevant to their liability or who is liable for what particular actions at what time. So that can get quite confusing. The letters and memorandums of wishes, we've talked about that before, and any other documents that are necessary for the administration of the trust. And you'll also need to, when a trustee, you know, retires, is removed, resigns, dies, you're going to need to get their documents as well. These days, I was talking about trust software. You would expect those to be held maybe in some kind of trust software. Some people just suggest, for example, you've got a shared trust Dropbox where all the information is kept together. People who may be familiar with law firms, you'll see that often they have both paper and electronic deed packets where they will, if they have been acting for a trust, keep those all together. But if they're not a trustee, that's still not going to be sufficient for compliance with the Trusts Act, because it needs to be a trustee who holds all of this information. And this is part of the reason when you're sort of weighing up the sort of benefits of, you know, a trust for estate planning versus, you know, whether or not it's, you know, more trouble than it's worth. One of the considerations you're going to have is the maintenance of all these core documents and the just keeping up with all of these requirements. And so, for example, if your main reason for having a trust is, as we discussed last session, things like the residential care subsidy, then when you balance out all of this stuff, it may, with the uncertain benefit that the trust may give you, you may decide it's not worth it. It's a very sort of case by case situation. So in terms of appointment and removal of trustees, so the average, okay. Okay, I see your question. And I have just lost my shared screen. Can you, where is that gone? If the trustee dies and their memorandum wishes says their land title goes to a beneficiary, but their will states it goes to another beneficiary, which takes priority? Well, it all depends on who's actually holding the land. So the will can only state it should go to a particular beneficiary if that piece of land is actually held personally by the deceased testator. If the land is held by the trust, then the trustee should be guided by the memorandum of wishes. So it all depends on who holds title. Sorry, that was just an answer to a question that just came through. Okay, sorry. Okay, so original trustees are appointed by the settlor on creation of the trust. The trustee will also specify the minimum number of trustees required to make decisions, and you will recall that there is in law no minimum number of trustees. However, the Trust Act does say that you can't be the sole beneficiary and sole trustee. So often it's going to be the case that maybe a minimum of 2 or 3, or they might say it needs to be 2 natural persons and 1 corporate trustee. The trustee will also say if you're ever down to 1 trustee for a particular reason, then that person can make whatever decisions might be required for the appointment of a new trustee or the vesting of property in them, but can't do anything else. They have some limited powers so that the trust can continue to tick over, but they can't, for example, make distributions or make any big decisions. And there are rules in the Trusts Act which talk about that, set out how a replacement trustee needs to be appointed. Just noting, trustees can just retire from the trust. They do need to follow a process for that in order for it to be all recorded and noted. And they could just die, or for what we look at, they can be removed from the trust. And the Trust Act sets out circumstances of both compulsory removal and optional removal. And in a sort of worst case scenario, the court does have the power to remove a trustee under Section 114. There are mirror powers under the Administration Act for the court to remove executor or co-executors, for example, if that is holding up the administration of the estate. But once it passes from an estate to a trust, then arguably the Trust Act provisions apply. That's a technicality that lawyers will argue about, but doesn't really affect you. Okay, so if you were cared enough to read, it's worthwhile looking at Section 92 in terms of powers of removal and appointment. But essentially, the significance here is that it does set up a hierarchy of who can be appointed. And if there is basically no one there, then the new Trust Act does set up the ability for property managers under the 3 PNR Act, so that's the Protection of Personal Property Rights Act, which we looked at, or the holder of an EPOA to step in to appoint remove trustees. This is significant because prior to this, if you had a situation where you had a trust and one trustee lost capacity, then, and for example, that trustee loses capacity, and then you need to sell the house because it's an elderly couple and they need some funds in the trust to support these people, you're going to have to go to the High Court for a vesting order. And you also need to get orders that would have the Land Information New Zealand, the Registrar of Lands, agreed to transfer over the property into the names of essentially the surviving or remaining capable trustees. So these are quite significant, and it also links into why, why this is a bit of a jigsaw puzzle, and so why, you would look at the terms of the trust deed and estate planning to figure out who might have this power of appointment if someone is unable or unwilling to act. but also look at who is holding the EPOA for property, because they, in some circumstances, might actually have the power to appoint and remove trustees. And it may be that you would put in your EPOA for property directions as to how that person should exercise that power if you were to become incapable. So, as I said, jigsaw puzzle, sometimes documents that you don't think are related or significant to one part of the estate plan could actually be quite significant if something goes wrong. And generally that's, what lawyers' jobs are. It's to figure out if something goes wrong, what's going to happen then. So you're trying to think a few steps ahead. The danger, of course, that leads to terrible overthinking in your personal life, but we'll leave it to one side for now. Anyway, so if we look here, so removal is compulsory. So someone needs to get removed from the trust, and that also means, of course, because they can no longer sort of exercise their duties if they lose capacity. And they look there about that delegated in a manner authorised by an enactment or by the terms of the trust. And if that's the case, so you'll see their losers capacity is also sort of in accordance with if the court has determined that you can't manage your property under the Personal Property Rights Act, then you are going to also not be able to exercise your powers as a trustee. You need to be removed from that trust. And that doesn't just mean, there's a sort of piece of paper that says you're off the trust. It means all the property that you are, holding as a trustee in your legal name with the other trustees needs to be vested or transferred into the names of the remaining and or new trustees. And that could or could not be quite a big job, depending upon the amount of property that a trust may have. Remembering, for example, that if you're replacing a trustee, the bank will require, or the AML or the, identity verification, etc., of that new trustee. And again, you've got those circumstances for optional removal. And basically this is usually used for that repeatedly refuses or fails to act. So when you've got a difficult trustee, if you've got 3 or 4 trustees and someone's just kind of, gone a bit off the reservation or is being deliberately difficult, is not cooperating, and it could be because they are a beneficiary themselves and are unhappy that they haven't been given a distribution, etc., then they can be removed. However, what the courts will sort of look quite sort of sternly at is if you are considered to be removing a trustee who's just being an inconvenient conscience. So if you've got a trustee who sort of says, I don't think that's a good investment because, and actually has some really good reasons for that, but the other trustees might wish to go ahead with something that could be reckless or otherwise inconsistent with their duties as a trustee, then those other sort of trustees can't just remove the inconvenient one, particularly as the courts could get involved at the initiative of either the beneficiaries or that trustee who has been removed or with whom there is an attempt to remove. And again, basically, you can't just point to someone and say that person is to become a trustee, which makes sense. They need to expressly accept that. Although it could be implied through conduct. Usually what you have are deeds of appointment and just even removal or replacement of trustees. So you've got that paper trail, and that also, as we'll look at, those deeds will also talk about, what is to happen about trustee liability, continuing indemnity of retiring trustees for actions that they took while being a trustee. All of these kinds of things will be built into that deed. So that's why lawyers like paper trails. And very rarely would a professional trustee, do anything until all the paperwork is signed that has the necessary protections for them to become appointed or removed. Okay. So trustees, just generally, even before the Act, as you'd expect, could be held liable for breaches of their duties, which includes those fiduciary duties that have been developed by the common law, and equity, which are, those which we'll see are reflected in the mandatory and optional duties or default duties under the Trusts Act, and those duties to act in good faith in accordance with the trust deed, etc. You'll see, let's check. Trustees can be paid, but usually that's going to be a professional trustee. If you're a trustee beneficiary, you're going to take distributions. But again, it's going to come down to the terms of the trust deed, whether or not that allows a trustee to be paid. And if you are asked to be a trustee of a trust, that might be a question that you're going to ask. You would also be asking, if you're going to become a trustee of the trust, to see all the financial documents in advance, to read the trust deed, to have some disclosure about issues relating to the trust, potential risks facing the trust, etc. Otherwise, you're going to be going in quite blindly and could be stepping into a minefield. But you can see sort of acquiescence and breach. So even if all you do is step back and avoid conflict and allow another trustee to breach the terms of the trust, you could be held liable. So in essence, if you are held liable, the first step is that you yourself are personally going to be held liable for the losses arising from that breach of trust. But you may be entitled to relief, and we're going to look at indemnities. I wouldn't know the rate of pay for a trustee, to be honest. I think it would vary quite considerably. It could be done on an hourly rate, it could be charged per transaction, per year, whatever. So yeah, basically the trustee liability, because again, remember, the trust is not a legal entity, and therefore sort of on the face of it, any actions that the trustee takes, they're taking personally, and therefore they are liable for those actions personally. But in some circumstances, you're going to be entitled to relief. Does anyone heard of, I'm going to look at indemnity clauses, what an indemnity is. Anyone know what an indemnity, if you say, I am going to indemnify you?
It means like maybe protection against a loss or a financial burden.
Yeah, so it's usually often going to be a compensation for a loss. So it basically says if you lose money or property or something as a result of an action you take, usually for me or in my interests or in the trust's interest, then the trust will repay you for that loss or will compensate you for that loss. So it's all balanced out. The circumstances is like that, of course, it's going to be quite important to encourage people to become trustees, that if they just have a small misstep, etc., or things go wrong, then but they act in good faith, otherwise they don't want to be out of pocket. But again, you don't want to also, on the other hand, incentivize people to act recklessly. You don't want to say, well, the trust, whatever happens, the trust will repay you, the trust will cover the situations. Yeah, so and again, it is sort of liability from being sued, but it's not a protection. So you can still be sued, but the trust may cover your legal costs, etc. And you can be sued both in your personal capacity and kind of as a trustee. It gets quite confusing. But the important thing is that the Trust Act sets out limits on those exemption and indemnity clauses. So the first part is that it cannot exclude a trustee's liability for any breach of trust arising from the trustee's dishonesty, willful misconduct, or gross negligence. And we're going to look at what the definition of gross negligence is under the Act. So you can't exclude them from liability under the Trust Act, and you can also not indemnify them for any liability for dishonesty, willful misconduct, or gross negligence either. Just as a note, for example, on this limiting or excluding liability, when you see, for example, professional trustees or professional trusts, corporate trustees, then they may, of course, be acting with a number of other trustees on a trust, and the trust may borrow money from a bank for a mortgage, etc. The corporate trustee will usually place a condition on their agreement that their liability under the trust is limited in some way, often to the assets in the pool of the trust. So it doesn't go beyond that, so that it can be, so that they aren't stung for any unforeseen losses or any sort of just general sort of adding up of interest, penalties, etc., for the failure to pay a mortgage, which may go over and above the actual assets held and the initial sum for the mortgage. The terms will vary, and I'm not an expert on this, but these are the technicalities that professional trustees will usually want to make very clear before they sign any sort of big document. And the paid advisor, so you'll recall there's the special trust advisor and the paid advisor, and the paid advisor is often going to be a lawyer, for example, who's drafting up the terms of the trust. And if the paid advisor is drafting up a trust and sees that there are liability and exclusion clauses and indemnity clauses, then they have to tell the settler what the effect of those are, and essentially act in a way to make sure that they aren't put into the trust deed inappropriately, because they're not going to be enforceable, and that could lead to some sort of difficulties down the way if someone agrees to or becomes a trustee and not understanding the limitations of those clauses. You'll see that the test for reasonableness here, or the test for gross negligence, is quite sort of consistent with if you've studied basic business law or had any encounters with the law when they talk about these reasonableness tests. So you're looking at whether the trustee's conduct, including action or inaction, and that's really important. So a failure to act is just as important as an action. And it would have been so unreasonable that no reasonable trustee in that trustee's position. So that's going to be also taking into account higher levels of accountability or expected knowledge from a professional trustee than, basically, mom and pop type trustee situation, and whether or not in the same circumstances would have considered that the conduct to be in accordance with the roles and duties of the trustee. And there's a long list of things that they need to take into account, including sort of intentions, circumstances, nature and seriousness of the breach of trust, purpose of the trust, the type of trust, and basically any other circumstances that the court considers relevant. Okay. So the inclusion of mandatory and default duties in the Trust Act is considered to be a significant development, and these duties aren't necessarily new, but they're the first They always existed, but this is where they are now crystallized. And the law also makes clear there are some duties that you are always going to apply and some duties that you can contract out of. And these mandatory duties, these 5 duties here, are the ones that you cannot contract out of. And this is the duty to know the terms of the trust, which kind of makes sense. But you'd be surprised how many people might not read that document in full. And particularly older trust deeds aren't actually that easy to read, even for lawyers, and will often require some specialist advice, particularly when you're getting into some difficult questions about, should certain distributions be made, can this variation of a trust deed be made, etc. So you need to not only know those terms. Yeah, so Jan's asking, there are many mum and dad family trusts with them as trustees, but they have no clue on all of these rules. Is that an issue? The answer is yes. That could be an issue. It's usually going to be an issue, for example, now if the IRD chases you up, or as we'll look, if that mum and dad have some beneficiaries that are more than them, that are, that are not them, other family members who could chase things up. If they could be finding themselves in the midst of, for example, relationship property claims, all of those things, insolvency, all of those things could lead to the point where a trust is considered a sham trust, or transactions could be opened up, or in some circumstances you could be looking at, accusations of gross negligence, etc. So transactions can be opened up. But the thing is, it's hard to know the level of risk. So there will still be a number of trusts that will continue ticking over, and they aren't being administered properly. And then upon the death of the settlers, they'll be quietly wound up, with the lawyers probably telling, and the accountants probably telling the family this wasn't done properly, but the family's like, oh, okay, and then they just move on. In terms of how that can be fixed, a lot of it is provision of information to people. And that's difficult, but that's also why it's good for people like yourselves, who are going to be talking to people who have trusts, or who currently are operating trusts or thinking about trusts, that they have an understanding of what those obligations are. When the Trust Act came in, most of the lawyers, accountants, etc., did write to their clients if they still had records and were holding trust deeds about these changes. But who knows how many clients just put those letters or emails just to the side, and the difficulty is then following up with everyone. So that's a long explanation, but yeah, it is a problem. And part of the issue why the Trust Act was put into force and the provisions are as they are is because of those concerns about how trusts were being operated, particularly just because there was such a big boom and everyone needed their own family trust. I think in the 1980s, 1990s particularly. Duty to act honestly and in good faith is another duty. Duty to act for the benefit of beneficiaries or to further the permitted purpose of the trust. That's quite an important one, and it can have some fish hooks. For example, when you've got something like a mum and dad trust, and despite the fact it might name, a number of other sort of family members as beneficiaries, the decisions that they make will be purely in their own self-interest, and won't necessarily take into consideration the needs of other beneficiaries that they have named in that trust. And they also need to exercise powers for proper purpose. And that links back, for example, when we were talking about the power to remove trustees or replace trustees, and we're also going to touch on the power to change beneficiaries. All of these powers need to be exercised for a proper purpose. And then, and I know this is a lot of small writing, you've got default duties. So these default duties may be modified by the terms of the trust, and a number of existing, even older trust deeds will disclose already either expressly or impliedly modify these, or just say that they are not bound by these. For example, things like the duty to invest prudently could be often excluded or limited, so that a trust could invest in something that may or may not actually receive good returns, but is consistent with the interests of, you know, the settlers, trustees, etc. Linking to that, though, I have had participation in a webinar where they were talking about climate change, etc. And some of these sort of powers or obligations of trustees to take into account future climate change, both in sort of investment in shares, etc., but also the purchase of properties, and also saying that trustees could be held liable for purchasing, for example, a property that's where there's sort of erosion by the sea. And if the property then sort of falls into the sea after 50 years, then there could be some liability on the trustees who purchased, although they might not still be alive. But yeah, the default duties are modified on a case-by-case basis. And a good trustee and a good set of lawyers will sort of advise the settlers about, and talk to the settlers about which ones may or may not be appropriate in the circumstances. For example, some of that duty to avoid conflict of interest, etc., duty not to act for reward. So that's again, that could be, we were talking about the payment of trustees, that would then need to be tailored or modified to allow professional trustees to act for reward. Conflicts of interest, for example, if you're both a beneficiary and trustee, should you be able to make some decisions which are in your best interest? The answer is usually yes, but sometimes a trustee may say that there must be at least one impartial trustee involved in those decisions. All of those kinds of things, so you can tailor it to the needs of the trust, and particularly when you've got smaller trusts, many of these will need to be tailored. Any questions on mandatory and default duties? So these apply, all of these apply. The only exclusion is you can, unless the trustee says otherwise, and it's only the trustee says otherwise for the default duties. Okay. So you might have seen, I did include within the readings a sort of precedent trustee. They vary so much, and it seems that there becomes a bit of fashion for trustees. So if you have to read trustees, you'll soon become, you know, as a job, you'll still soon be able to see, okay, that without even looking at the date when a trust was settled, you'll still be able to go, that's a 1960s trustee, that's a 1970s trustee, particularly when you're in sort of private practice, and we were operating in a small provincial firm, would know this trustee comes from this particular firm, this trustee comes from another firm, from a particular era, or partner of a firm who liked these particular clauses. They vary greatly. So for example, some of them you have to dig like 6 pages in to even find the name of the trust, and it will be in tiny writing. Others will usually say that at the top, little things. But what that means is that it is really, really important to read the trust deed and get an understanding of what the provisions of that trust deed are. And this is, you know, from an example of what could be quite a modern trust deed, and I just added random names in here. But again, this trust deed is naming what is quite a sort of smallish pool of beneficiaries here. So it's talking about the settlers, and in this, you know, example, the settlers you can assume will be also the appointers, which is Jane and Timothy. And they're saying every child they are going to be discretionary beneficiaries. Every child of theirs is going to be a discretionary beneficiary, and then every grandchild of theirs is going to be a discretionary beneficiary. And then any other beneficiaries appointed under the subsequent clauses of this deed. So whether or not that deed mentions or creates other classes of beneficiaries is possible. It's also that there could be variations of the trust deed or by the appointers, depending on how the trust deed is written, to allow them to appoint more beneficiaries. And then the final beneficiaries in this case are the children of the settlor. So that means that at the time that the trust is to come to an end, then that Samantha and Samuel would be to share in the trust fund as set out in the memorandum of wishes and or the trust deed. As we'll see why this is important next when we're looking at particularly the issues relating to disclosure to trustees, to beneficiaries, but the trustee will set out who can vary the terms of the trust and also who has the power of removal and addition of beneficiaries, or at least it should. But again, those powers need to be exercised really carefully. So an example that I am aware of is I had a partner, as in a law firm partner, who had a husband and wife who had a trust, family trust, but with some significant personal assets. And when they set that up, they named all of their children, I think, there are 3 or 4 of them, as being discretionary and final beneficiaries of that trust. They then had a falling out with one of the daughters. And this was for serious reasons, including that the daughter had chosen to stay with her husband for religious reasons, despite the fact that there were very real concerns that the husband had abused his children, which would have been the settlor's grandchildren. And so these settlers, these parents, they no longer wanted their daughter to benefit from the trust. But it wasn't just as simple as removing that daughter from the trust, because they needed to show that they were doing this in good faith, and whether or not there were other ways of sort of going through the process to protect the assets and also to protect any transactions. So even just winding up and emptying out the trust without telling the daughter was an issue. So these are not nice, straightforward decisions. And particularly these decisions were also being made before the new Trust Act came into force, which will be quite significant, as we'll see. So, and you may be aware of this, but this, or if you've read the notes, you'll have seen this. This was considered to be one of the biggest issues or biggest developments in the Trust Act. So there had previous to this been quite a bit of litigation on what rights beneficiaries had to trust information and to find out about a trust, and basically so that they could assure themselves that the trust had been properly administered, but also to often figure out why they hadn't got anything from it, or why they weren't getting anything from it, etc. And one of the biggest cases on that was a Supreme Court decision called Urseg and Urseg, where it was after the death, I think it was Michael Urseg, one of the big liquor barons. He left behind a few trusts, and one of his brothers took a lot of litigation to find out more about those trusts and why he should be, because he wanted to know why he hadn't received some distributions from it. And the Supreme Court then set out a number of principles that needed to be considered, but there was still a degree of uncertainty as to how that would then apply across the board. And however, even applying those provisions, there were situations, for example, when a daughter had, just this very standard kind of family trust, had gone considerably off the rails to the extent that she had been involved in drugs, but not only just involved in drugs, but involved in criminal acts against her own parents, who were the settlers and trustees of the trust. And in those circumstances, before the passing of this legislation, it was considered that it wasn't appropriate to give her any information about the trust, particularly since the court had very good reasons to consider that she would just be using this as basically a weapon against her parents and against her wider family in what was just a continued war. Can't recall right now if there were also applications to remove her as a beneficiary. I don't think the parents wanted to completely cast her off, but they just wanted to make sure that she didn't know too much about what was actually in the trust and feel that she had an entitlement to distributions or use the information she gained, as I said, for ulterior motives. But coming back to the Trust Act, the starting point is you need to give every beneficiary basic trust information. And that includes the fact that a person is a beneficiary, the names and contact details of the trustee, and the change of trustees, and that the right of the beneficiary to request a copy of the terms of the trust or trust information. So when we go back to, for example, the trust deed, this is why it's quite important to set out who is a beneficiary. Because in this case, it's quite easy to do. You've all, Jane and Carolyn need to do, Jane, Carolyn and Timothy need to do, if they are the trustees, is tell Samantha and Charles. And if Samantha and Samuel, I wrote these names and then can't even remember them. If Samantha and Samuel then have their own children, then if they are minors, then they would be considered to be representatives. But once those children turn 18, then those children would be also entitled to some basic information about the trust. But in some circumstances, it can get really wide, and it can talk about spouses. It could be set up so that in some circumstances, you know, you've got tens of beneficiaries, all of whom need to be kept track of and need to be informed about the basic trust information. So as you'll see there, basic trust information includes a right to request further trust information. And further to trust information includes the terms of the trust, administration of the trust, information about how, like for example, some of the financial information, and information about the trust property that is reasonably necessary for the beneficiary to enable the trust to be enforced, but doesn't always or necessarily include the reasons for the decisions. And if you ever have seen sort of trustees' resolutions, etc., they're usually quite carefully drafted, particularly with for the reasons of large distributions, so that it's usually very neutrally worded to make, because you don't need to necessarily include your reasons, but you also might want to make sure that it is clear that you've taken into consideration your duties as well. And all of these decisions are, so for example, the duty to give the basic trust information and also the duty to provide further information is subject to considerations that are set out quite extensively in section 53. And these considerations very much map across to that ERSEC decision that I referred to. So they clarify some points, but so these weren't necessarily new rights that beneficiaries had, but the beneficiaries could now point to, you know, some sections in the Act and say, you must give me this information. And so we've got a big long list there. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 considerations, which includes any other factor that the trustee considers reasonable. But these effectively are, you know, what are the nature of the interest in the trust that trust that beneficiary has any concerns about confidentiality, the age and circumstances of the beneficiary, whether or not there are other beneficiaries and what their circumstances and age are, the effect on the beneficiary. Sometimes it's considered bad maybe for the mental health of a beneficiary to know, what the circumstances of a trust are and the amount of money on it. Or for example, when we had that situation where the daughter was likely to use the information for ulterior motives, that was going to be a legitimate concern, as well as the effect of how she would be using that information on the trustees, the other beneficiaries and third parties and other relationships. The practicalities of imposing sort of restrictions and safeguards. The practicality in general, for example, if you manage to have a trust, particularly when you've got a very wide class of beneficiaries who might not be specified in any detail, if that's so large that it would be impossible to identify, on a practical basis, all of them and contact all of them, then you may be able to sort of not have to provide particularly that basic trust information. The nature and the context of the request and any other factor that the trustee considers is relevant. So really, really wide. Just as a quick note, and this is possibly more of a technical point for lawyers, this applies early on. So if you are a beneficiary and you want to know a bit more about some of the decisions that maybe even your parents have made about a trust, and you're getting a bit more difficult about that and they're not providing it too readily, then you could, then if your parents refuse to provide that information, then the court may need to make directions as to whether or not that decision is appropriate. However, if you take it further and you're actually suing your parents, then the information and what you're seeking would be provided under the rules of evidence and disclosure, etc., that are covered by just general litigation. So it's kind of a change there, and there's quite a bit of case law as well about litigation privilege, etc. So as soon as you start suing people, these rights change. You still have rights to information, but they're different rights, and they're applied and weighed by the courts differently. So we have touched on this. The court has some really wide powers. Generally, we are talking here about the High Court when it comes to trusts, particularly the size of trusts, but the Family Court also has some quite important powers, particularly with reference to the Property Relationships Act, and also while we look at the Family Proceedings Act and something called nuptial settlements very briefly in the notes for the next topic. But they also have powers that just come from common law and equity and the Trusts Act, etc. The Trusts Act is also considered sort of notable because it does consider or provide for the use of alternative dispute resolution. I'm assuming you know what alternative dispute resolution is. Does anyone know any kinds of alternative dispute resolution you could use? Yeah, so you could use mediation or counselling. You could also use arbitration as a way of looking at as setting a third party to make a decision. You can sort of set up all kinds of conciliation, various sort of formal negotiation procedures, etc. Essentially, you're looking at ways of resolving the dispute that don't use up the court's time, and also hopefully in some circumstances can be used to maintain relationships between parties, which when you think about things like family disputes, it's just really, really stressful and destroys relationships to go to court because they are adversarial by design. So one basically made the best person win, and you have to come up with your best arguments, and often that requires, you or your lawyers saying some quite hurtful things about the other side. And also, just as a note, most, and because of the principle of open justice, High Court decisions and all court decisions can be read, and very rarely will they be redacted or anonymized. So if you end up going to court and arguing about the administration of your trust, and it's got some meaty details in it, then it's going to, and it doesn't get settled in the shadow of the court room, which is very common, then it's probably going to find its way into a newspaper. But there is confidentiality and privacy and the ability to maintain relationships, and just the ability to manage costs and timeliness could mean that you might use alternative dispute resolution, and you might even have some alternative dispute resolution provisions within your trust deed. So just finishing off, just noting that some powers in the Trusts Act, which we, some of which we mentioned earlier. So the courts can make directions regarding the provision of information to beneficiaries. They can make orders for or preventing the removal of trustees and for the appointment or replacement of trustees. They have very broad powers to review basically the acts, omissions or decisions of trustees under Part 7. And as part of Part 7, and a trustee or trustees can seek directions about trust property or exercise of power or performance of a function. And that's actually quite important. What that means is, for example, if trustees genuinely don't know the best way to go, the best way to administer a trust, or whether or not they should make a particular decision or not, then they can, in good faith, go to the courts and say, this is the decision that is facing us. We don't know what to do. Should we sell this property? Should we give a distribution? What does this piece of the trust deed mean? And the courts can then provide some guidance on that. So it's quite a neutral thing. It doesn't necessarily mean that anyone has done something wrong. And in fact, it could be really quite proper practice, because if you've got a record that we asked the court before doing this, and it's going to be quite good protection, for example, against accusations of negligence or failure to exercise your duties. Okay, so that is the end of trusts. Hopefully that has made sense. Any final questions or comments? No, trusts can be quite fascinating sort of things. The overarching basics of trust can be quite straightforward, but just like any sort of piece of law, and just any kind of human relationship, really, they can get complicated. And trusts, just like many other legal structures, it's a question not just of law, but of those human relationships as to how well they function. So if there's no further questions, I'll end this recording for now and see you next week for relationship property. So
Thank you.
thank you.